Lawyers are trained to argue and parse the finer points of complicated issues. Recently, some of this province's legal professionals have focused their debating skills on each other, or rather, on a statement of principles that's generated enough controversy that it became the primary issue in the most recent election of benchers, who essentially act as the Law Society of Ontario's board of directors. Here to explain the debate, Murray Klippenstein. He is a lawyer and newly elected bencher at the Law Society of Ontario, and Karim Assad, Toronto-based lawyer specializing in criminal, landlord-tenant, and cannabis law, who was also a candidate in the most recent bencher election. And we're grateful to both of you for coming in to tackle what has been a thorny subject in the legal community for a bit. Here's how we're going to proceed. Murray, I want to talk to you off the top for a few minutes, then talk to you, Karim, for a few minutes, and then we'll discuss, because I think we need to know a bit more about your background, starting with, why are you a lawyer in the first place anyway?
Strange question. It was unimaginable for someone like me to become a lawyer because I actually was raised a Mennonite, which is a very conservative and rural grouping culture, if you will, in Manitoba and Saskatchewan. And because of the way we Mennonites operated, being a lawyer was not a thing. Not a thing at all, because we don't believe that we want to engage with the state system. So I never met or talked to a lawyer. I don't think I ever saw a lawyer till I was in law school.
So how'd you get in there?
Well, it was a long and winding journey, and partly I liked the idea of open-mindedness and helping people. My parents raised me as a bit of a do-gooder. I don't know whether that's good or bad, but it was very, very interesting, and it still is, and it's also very tough. But I think it's a wonderful profession. It's a hard road.
How many years have you been practicing?
About 30 years.
30 years, and what's your specialty?
Well, as I said, I'm a do-gooder, so I do work for I think people who are disadvantaged, and so I've worked a lot for Indigenous people and on affordable housing and civil rights, and I do environmental work, and so I deliberately created my own firm about 20 years and wanted to grow it because I wanted to have a firm that could focus on those kinds of cases, often suing governments, big companies, for people with no money.
Well, you say you wanted to grow the firm. How many members in your firm right now?
Well, now there's none.
Just you?
Just me, because of what happened with this topic, with the statement of principles. I concluded, and I agonized about this for more than a year, and I said the firm is not viable in the political climate caused by this compulsory statement of principles. So I've wound it down.
What was the problem with what the statement of principles said that you found objectionable?
Well, the statement of principles says that I have to adopt and abide by principles of somebody else's choosing, which I consider to be political, and whether I agree with them or not, I said frankly, as a Canadian and especially as a lawyer, and just as me, I simply will not sign on to a statement of principles that someone else dictates to me. And when I took that position, it took me a year of sleepless nights almost to decide that. I knew I would lose my reputation. The Law Society said it would enforce this, which meant eventually I would be disbarred. That was where the road ended. My clients would wonder why I'm taking this strange position, and my associates might not agree with me. So incredibly sadly, I wound down the firm I spent 20 years building.
And yet, you ran for a bencher position, which, as we suggested, is like being on the board of governors or something of the Law Society, and you came first, right?
It is mind-boggling and stunning and humbling. I came in first in the vote in Toronto, and I had repeatedly put forward my position in a couple of articles, people can find them online, about why I thought this compulsory statement of principles was bad for lawyers who are supposed to be independent thinkers and fight for the rights of people without interference of anybody, and bad for me as a Canadian. And I put that out there thinking this was the end of me. This was the end of my career that I'd spent 30 years in, the end of my firm. I thought this was the end. Nobody wanted to talk about it. And I put that out there, and I guess I think I struck a chord. I don't know. A lot of people in the profession voted for myself and the other 21 people on this slate. We came in Toronto, we came in the top 10. And once, I think, people felt that they were not allowed to discuss this issue openly, but when they went into the proverbial ballot box with the secret ballot, and this is one of the beauties of democracy, they said, I'm not going to vote for that.
Well, we're going to talk about it openly here on the program tonight, so thanks for getting us started off. Karima, same questions to you off the top. Why are you a lawyer?
So my path to law also wasn't super straightforward. When I was in my undergrad, I was studying international development, and I landed up in India working at a human rights law firm. And that was really my first exposure to lawyers. I'm a first-generation Canadian, and I hadn't really contemplated being a lawyer and seeing how the law could be used as a tool for social change and equally a tool of oppression really struck an interest in me. And from there, I transitioned to law school, and now my work involves primarily frontline access to justice work. I do criminal files, landlord-tenant files, and I'm active in the cannabis space. And that is really, I'm thrilled to be doing what I do.
I'm guessing you don't defend too many millionaires.
I haven't, I don't think, come across very many millionaires, except maybe in my dealings with other lawyers.
That was well put. How long have you been practicing?
I got called to the bar in 2016, and I set up shop in 2017.
Okay, you've heard what Murray had to say about the statement of principles, so-called. What's your view on them?
I mean, I think the fundamental question is there systemic discrimination in the legal profession? And if we answer yes to that, then the next obligation or responsibility is how do we address it? And what I understand from the statement of principles is that it's meant to reinforce, reiterate existing obligations. And it's really a look or an attempt at engaging self-reflection. And so sometimes when we're asked to self-reflect, it can be an uncomfortable experience. We may not like what we see in the mirror, but the language of the statement of principles, the requirement itself, although it asks us to adopt and abide by principles, these are principles that exist whether or not we have a statement of principles. And they are found in our rules of professional conduct, in the Human Rights Code. And so I'm troubled by the reaction to what I see as a very simple first step. No one was required to publish their statement of principles. It's meant to be, again, an internal act of self-reflection. And in a world where most Canadians cannot afford lawyers, and the price of law school tuition is beyond reach for the average Canadian, and we're facing other crises of access to justice, for this to be the issue that people rally around, I simply do not understand.
The statement of principles included things like there has to be a respect for diversity in law firms, and I think it only applied to law firms with, what was it, more than 25 lawyers, something like that?
Something to that effect. And I mean, the notion of diversity as a form of strength, I think we can refer to the Supreme Court of Canada's language in the Trinity Western decision, where a diverse bar is a more competent bar in that it represents the public we serve. And so I see the statement of principles not just about what's required of an individual lawyer, it's more overarching, what's best for the public. And look at the data, right? I do criminal law, and we know very well in the criminal justice system that certain groups are disproportionately represented in jail. Why is that? And as lawyers, we play a role in the justice system. So for us to self-examine, I think, is a necessary task. It's a privilege to practice law. And I think it's important that we consider to what extent do our actions either promote, and by promote I mean uphold, diversity and inclusion, and where can we do better?
One last question before we start our discussion, and that is, you, like Murray, ran for a bencher position at the Law Society. Didn't happen for you. Do you know where you ended up?
I came in 28th, so I got 2,550 votes, which I'm quite pleased with, I'm proud of. I was running as an independent. I had no sponsor or backer, so this was me connecting with people, and I ran on a platform about reducing barriers to entry and practice in the profession, because there are issues that need to be addressed in that regard. And I will say that although the slate did take the top 10 spots, it was a very effective and strategic campaign in the sense that there was a concentration of votes. And so looking at the numbers and looking at, unfortunately, the lack of voter participation.
I think there was, what, about a third turnout, something like that?
Something like that. I think 16,000 votes in total.
Out of 50,000.
Out of 50,000, and 22 who were running on a Stop the Statement of Principles campaign. Many other candidates were pro Statement of Principles, but I do believe that that vote got diluted. And so that's where we ended up.
Let's, you know, Marie, what I want to pick up on is that Karima suggested in the beginning of her answer a few moments ago that if you believe there is systemic racism in the justice system, then you need to do something about it. And she was comfortable with the Statement of Principles as an initial response to that. So let's start there. Is there systemic racism in the justice system in Ontario?
Well, that's a bit of a trick question, and I think the answer is probably yes. But here's the thing. What the Law Society did quite a few years ago was start a process to investigate challenges faced by racialized lawyers in the profession. And they spent, you know, a lot of money, I don't know, 100,000, 200, 3,000, I'm guessing, on a bunch of studies, including a survey and so forth. And when this came up, I said, I must be wrong. I must be misunderstanding something. I've been fighting racism all my life, often at great personal cost, among other things. And every step of the way, I felt that this process was misrepresentative, manipulative.
The process of the Statement of Principles?
Of the whole study, and ideologically driven at every step of the way. And this is from somebody who started out sympathetic. And so I didn't trust that process, and now I don't trust it. And I think it's very unfortunate, because if that process had happened in a way that actually looked at, you raised the question of systemic racism, what is going on there and what are the solutions? That is what I would want. It's too late for that now. The damage has been done.
Okay, Karima, I think part of the issue the other side had, as I understand it, because we've done a program on this before, is that, I mean, nobody's going to argue against diversity, but the notion that you would have to, as a law firm, sort of tell what the demographic makeup of your law firm is to the Law Society, have that information published for them, and then they will rank law firms in the province by who's sort of meeting the targets and who's not, many people found problematic. Do you see a problem with that?
Well, I'm not sure what targets we're referring to, because there is no quota system, there are no targets. It's about data collection, right? And what do we then use that data for? That's a very valid question. And, you know, I don't have the precise answer to that, but at least knowing the extent to which diversity, however we formulate that, is existing in law firms, that at least gives us ground to then tackle the root cause of any issues that may exist.
I misspoke. She's right, Marie. There's no targets actually set out in the principles, but can you imagine that some of the bigger law firms would have been, let's say, embarrassed had the numbers been published and we finally discover that Smith, Jones & Jones have only 2% racialized lawyers at their firm?
Well, I think, if I may, I think it's a correction. There are targets, and what they say is that, this is very important, racialized members of the professions, lawyers and paralegals, should be represented in law firms in every workplace at every level equivalent to the population. That's a de facto quota, which is hugely important. And if I can go back...
It was aspirational, though, I think. It wasn't mandatory.
Well, this gets back to, you know, the whole idea of diversity. I object to anybody, as a lawyer, as a Canadian, a government, telling me what my principles are. I think that's foundational to our society. Many people maybe not, don't think about it as much as perhaps maybe we need to sometimes. But regardless of what those are, and you mentioned diversity, well, first of all, this does apply to every single lawyer individually, not just firms. And secondly, you know, when you get into the issue of diversity, you know, my friend said this was really about making us reflect on it. Well, I did. My whole career was, and I reflected on this and I said, there are problems with the idea of diversity, the word. It's often misused. It's a code word. It's a mask for a whole bunch of other things, which I think are quite ideological.
Well, let me put
That's
the
just
math.
me. Yeah.
I get you. Let me put the math to Karima. If, and I believe Maria is right about this, if the aspiration is that the legal profession ought to look like the population it serves, in other words, half the lawyers in Ontario ought to be women, whatever the percentage of Muslims is in the population, that should be the number of lawyers. Whatever the percentage of Jews are in the population, that should be the percentage of lawyers. Can you understand why some people might find that problematic? Sounds like a quota.
Again, as far as it being an aspiration, I think some of the concern comes from, well, what about merit, right? What if we are focusing too much on diverse criteria, we're going to lose sight of merit? Well, I think the problem is that merit's actually, scattered fairly evenly across demographics, but we don't all have the same opportunity, right? When I went to law school, it was between $12,000 to $14,000 a year. If I was to go to the same law school today, we're looking closer to $18,000 to $20,000 a year. I would not be able to afford to go, and I would then not be a part of this profession. And I say that as a woman, a racialized woman, a Muslim woman, wouldn't be having this conversation with you here today. So the idea that if we improve the representation and we're closer to the community, that's somehow going to lose meritorious lawyers, I do not buy that argument.
Murray, access is a thing in the legal profession, isn't it?
Huge,
Right.
and I totally agree with Karima. I mean, the tuition fees are an appalling, barrier to people of all, whatever origins. But I think that there are, when you look at a problem, I sort of come to the conclusion over the years that a lot of problems have multiple causes operating at the same time. And if there's a lack of representation, it could be, some racism, and that is a very bad thing, which I would like to know more about and how to address, but that's not the only thing, including different cultural origins. People who come to Canada from different cultures have different views about the legal system. And my own background, lawyers was not a thing. In many communities that I'm familiar with, people should rather be a doctor than a lawyer. So there are many causes, and we should find those. And to the extent racism is part of it, absolutely. But it's not, I think, accurate to say there's systemic racism in a way that we should trumpet, because honestly, I think we're pretty good in the profession in a lot of ways.
Okay, let me hear Karima on that.
I'm going to jump in there and say that as lawyers, we consider ourselves to be the last bastion of democracy, right? We are the architects of social change. We hold a lot of responsibility. We're leaders in that sense. And not all discrimination is obvious. A lot of it is subtle. So I will give you an example from my own experience. Leading up to the OCI process, which is a recruitment to big law firms, many of the events are cocktail-oriented, and I don't drink. And so that then caused a little bit of discomfort when someone would offer a drink, and it's, do I give them my real explanation? Do I have to get into that? Can I just say no? And that's just one small example.
Well, the golf course is another one.
The golf course is another one. And we know from studies outside of the legal profession that we tend to want to surround ourselves with similar people. So if you're in a hiring position and there's two equally qualified candidates and one of them, I can't pronounce that name, I'm just going to go with Joe because Joe looks like me. Joe likes the Maple Leafs. Joe's father is a member of my country club. And so it's not all obvious. And again, the statement of principles is meant to reflect, and we can all do better. And we can all think about in what ways am I potentially enabling progress, and what ways am I detrimental?
We're down to our last couple of minutes here. I do want to give you a chance to respond to that. The scenario she has just described, that is accurate. You would agree?
Well, if being offered a drink at a cocktail party to which one can simply say no, and if that is systemic racism, I mean, I can see the concern, but if that's...
She didn't call it systemic racism, but she said it put her at a bit of a disadvantage. Like when the 60-year-old white men all want to go golfing, and that's where they're going to do their discussions about promotion and so on.
Well, those are quite different things, and what I think would be very good, which I wish the study had done, is look at those things. And I think that being forced, and again, this is a compulsory individual statement of principles, so that's an issue of freedom of thought and expression. And then this is other issue. They're different issues, and we shouldn't treat them as one issue.
Okay, let's do this, because we got a minute left. I want to give 30 to each of you. You won. You're a bencher. The majority on the Law Society Board of Governors, if you like, agrees with you. So is the statement of principles dead as far as you're concerned? You guys are going to tear it up?
Well, tear it up is a bit of a bad word, but a vote is coming up planned in about a month from now. When you add all the votes together, we don't have in our group a majority. So I don't know what's going to happen. I hope that there are benchers who voted for it last time who will reconsider because of the election results and perhaps abstain. We shall see. I think that what was formerly a silent issue, because people like me are always called, if we talk about this, we're called racists and sexist and phobic this and phobic that.
No one's called you that here today.
No, but I've been called that, and
okay.
And there's more. I assure you, it's out there big time, and people know that, and so they don't want to talk about it. So maybe this is a time for, looking at and yes, look at racism. We need to solve that problem, but a different problem is being forced to say things that one should be able to think about.
Okay, and Karima, you didn't win, so you're not on that Board of Governors, if you like. You're not a bencher able to implement the agenda you wanted to see. Does that suggest that the statement of principles is over and you're going to have to figure out another way? Not
necessarily, and there's a lot of work that can be done from the outside. What I would encourage current benchers to think about is the mandate of the Law Society and what is it there to do. It's there to promote the public interest. The statement of principles, as I see it, isn't about individual beliefs, and in fact, the guideline for interpretation is very clear on that. It's about acknowledging pre-existing rights and obligations under the code.
I know the two of you disagree vehemently on this, but I do want to thank both of you for having such a thoughtful and civilized discussion here in our studio about it.
Can we have an extension to argue some more?
I'd love it if we could, but sadly there's only 60 minutes in an hour and there's nothing I can do about that. Murray Klippenstein, Karima Saad, thanks so much for coming into TVO tonight.
Thanks for having me.
The Agenda with Steve Bacon is brought to you by the Chartered Professional Accountants of Ontario, helping businesses stay on the right side of change with strategic thinking, insightful decisions, and business leadership. Are you on the right side of change? Ask an Ontario CPA.